So welcome everyone to our Lunch and Learn with Justice Lalit on India's innovative approach to public interest litigation. My name is Tony Verona, and I have the very big honor of serving as Dean of the Seattle University School of Law. I welcome our distinguished speakers, Justice Lalit and Vice Chancellor Raj Kumar. We also welcome the other members of the delegation who are here from O.P. Jindal Global University, Dean Bardwaj, Ambassador Kumar, and Dean Paddy. We are so delighted to have with us 27 students from Jindal Global Law School who are at Seattle University for 3 weeks for a course on AI, tech, and the law. They are joined by the distinguished Professor Hundlini. So we welcome all of you, all of our distinguished guests, all of the faculty, all of the students, all of the dignitaries. We're also very grateful that this is a collaboration between the Seattle University School of Law and the International program, of course, here, and Round Glass India Center. Our university was founded over 125 years ago. It's located in the heart of Seattle, one of the most exciting of the global tech hubs. I was delighted and honored to create and launch our first associate deanship for international and graduate programs, and Professor Kalantri served in that role for the first 3 years of the existence of that role. And she essentially, leading the effort, took our international program from having 3 international LM students to over 30. We launched a new SJD program, many initiatives such as this one with partners around the world. And so Dean Kalantri really deserves a tremendous debt of gratitude from all of us in building our international program in such an impressive way. Under the direction of our new Associate Dean for International and Graduate Programs, Russ Powell, who's over there, I'm sure that the program will continue to be very successful and grow the internationalization of Seattle University School of Law. We recently hired everybody, Professor Philippe Renninger, who was most recently the global law professor at the University of Arizona's Qingdao campus at Ocean University of China. He has joined us as a visiting assistant professor and the assistant director of our international and graduate programs focused on global engagement. So he will, I am sure, get to know all of you in the months and years to come. National Jurist Magazine has given our international program a solid A in its ranking of American international programs, and so we've made tremendous progress in a very short amount of time. The magazine also rated us a top international program in the United States, as well as naming us one of the top 20 most innovative law schools in the United States. Thank you. Our faculty continues to be ranked the #1 faculty in scholarly impact among all of the law school faculties in the Pacific Northwest of the United States by both of the national scholarly impact ratings, the FLAIR rating and the CISC lighter rating. And our alumni continue to be ranked #1 in the Pacific Northwest in the Thomson Reuters Super Lawyers rankings, recognizing the top 5% of practitioners across 70 areas of practice, many of those areas of practice immersed in international law and trade and transborder human rights law. Let me tell you a little bit about the India Center. The Round Glass India Center is one of the very few centers at any university in the US that focuses exclusively on India. The center was founded 20 months ago, and in that time has hosted over 20 events, including one with a member of parliament from India, 2 chief justices of the Indian Supreme Court, a Nobel Peace Prize recipient, from India, and 3 Indian American members of the U.S. House of Representatives. The center's webinar series on how the Trump administration's policies impact Indian Americans and India reached people in 35 of the American states, 25 countries, and 5 continents. The center has also funded 4 scholarships for master's students and awarded 12 faculty research grants. And it has launched a very popular, very successful podcast called Desi Roots, with 10 episodes released to date. We have Professor Kalantri to thank for all of the progress and the incredible achievements in such a short time of the center. And so I'm pleased to introduce our guest of honor, along with the director of the center and professor of law at Seattle U Law, Sheetal Kalantri. She is a tenured law professor and founder and director of the Round Glass India Center at Seattle University. She has written 2 books and published over 40 articles in major legal journals, such as the Cornell Law Review and the Stanford International Law Journal. She has published in peer-reviewed social sciences journals, and her opinion pieces have been published in the New York Times, Slate, and The Hill, among other very prominent publications. She's a regular media commentator on reproductive rights, law in India, and human rights issues. Her writing has been cited by the US Supreme Court and the Indian Supreme Court. She has received 2 multi-million-dollar grants to found centers at universities. She founded the Round Glass India Center at Seattle U to focus on the study of contemporary India and Indian Americans with a grant of $2.2 million. Previously, she founded the Avon Center for Women and Justice at Cornell Law School with a grant of $2.5 million. She teaches contract law, comparative constitutional law, and business and human rights. Her teaching is informed by her scholarship as well as her 7 years of experience as a corporate lawyer at 2 major U.S. law firms, Milbank and O'Melveny, and by her litigation experience in international and foreign courts, including the Indian Supreme Court, Inter-American Court of Human Rights, and Constitutional Court of Columbia. She has won many awards, including for her book, for her public interest work, and for her mentorship and support to women students. She received the Fulbright Scholarship to teach at Jindal Global Law School in India and to conduct empirical research on the Indian Supreme Court. She's a dear colleague and advisor to me as dean, and again, one of the very best decisions I made in my first year as dean here 3 years ago on my very first day was to appoint Sheetal as our inaugural Associate Dean for International and Graduate Studies. She's elevated the standing and prominence of our program, both internationally and domestically, and not only has had Seattle University and our law school go out into the world in ways that we had not for many decades before her arrival, but she has invited the world here to Seattle University and our law school. So thank you, Sheetal. Justice yes, first.
I'm sorry that you had to hear the long form.
No, that was important for you all to know who we have in Professor Kalantri. Justice Lalit is one of India's most distinguished, really, he is one of the world's most distinguished jurists and served as the 49th Chief Justice of India. After enrolling as an advocate in 1983, he began his career at the Bombay High Court before moving his practice to Delhi in 1986. There, he was designated senior advocate by the Supreme Court and took on pivotal roles as amicus curiae in several constitutional matters. He also served as special public prosecutor for the CBI and the landmark 2G Spectrum trial, helping to set new standards for accountability in public life. Elevated directly from the bar to the Supreme Court in 2014, Justice Lalit went on to deliver and shape some of the most consequential rulings of our time. He was part of the historic 2017 verdict, striking down instant triple talaq as unconstitutional, authored a transformative judgment clarifying the POCSO, the POCSO Act, to ensure that any act of sexual intent, not just skin-to-skin contact, constitutes assault, and upheld the Travancore royal family stewardship of Kerala Shri's Padmanabha Swami Temple in a closely watched case. As Chief Justice, he spearheaded judicial reforms to enhance transparency, streamline constitutional bench hearings, and reduce case backlogs. He also served as executive chairperson and later patron-in-chief of India's National Legal Services Authority, expanding access to justice for millions of vulnerable citizens. Justice Lalit's career embodies integrity, intellect, public service, and an unwavering commitment to the rule of law, qualities that resonate deeply at a time when courts across the country and around the world face unprecedented challenges in safeguarding democratic values. And before I turn the proceedings over to Professor Kalantri and Chief Justice Lalit, please allow me just one final second to share with you that I just got back very, very late last night. So if I appear a little tired and punchy, it is because I got back on a very, very late flight last night from the American Bar Association and Association of American Law Schools annual American Law School Deans Gathering in New York City, this year hosted by New York Law School. I had the honor of chairing the hosting committee, and we hosted the conference here at Seattle University last year. President Peñalver served as its keynote last year. This year, it was in New York. The dominant theme of this year's conference, the conclave of all of the American Law School deans, was the importance of the rule of law and how legal educators must partner with judges and elected officials and leaders of the bench and bar to defend and protect the rule of law and core structures of our democracy, especially at this moment in our history. All to say that gatherings such as this one, partnerships such as this one that we have here, that we're celebrating here this afternoon, are of critical importance as they bring together leaders in law from the world's largest democracy and the world's oldest democracy to talk about democracy, to talk about the challenges we face as educators and ministers of justice, as defenders of the rule of law, and as proponents of access to justice. So with that, friends, please join me in warmly welcoming Justice Lalit, who will be in conversation with Professor Kalantri.
Welcome, Justice Lalit. So we're so honored to have you here today. I'm going to just have a Q&A with him. That's one of the way how we will proceed. Met Justice Lalit in India, and I have to say he is one of the most humble and erudite people I know. In addition to being a justice, he's also a professor of law, teaching at Jindal, which is an oversubscribed class. So let me start by asking you about the topic of our discussion today, public interest litigation. When we hear that in the United States, we think of something very different than when it's spoken about in India. And part of my goal is, as a comparative lawyer, is to bring these conversations out to the public. And so I would love if you could tell us just briefly, how did public interest litigation emerge in the 80s and 90s? What's innovative about it, and what's different that the Supreme Court itself has innovated?
First of all, thank you. And it's a privilege to be here. Now, let me answer the question. When India gained independence, 20% people alone were just about above the average of literacy rate. Almost the large population of the country, 80% was illiteracy. So therefore, we have been troubled by that particular part. Though we are the largest democracy, most of the people were below the poverty line, below the what is called the literacy rate ratios. So in 70s and 80s, courts are normally concerned about the standing of a person who approaches the court as a suitor or as a litigator. So therefore, the first question which would be asked is, what is the grievance? What is the injury that you have suffered? What is your locus in the matter? Now, in a country where there are large pockets of illiterate people and populations and communities, perhaps I think the illiteracy would drive them to such extent that they may not even be able to have the wherewithal to approach the courts. So therefore, the first igniting spark was in a case which is we normally refer to as Bandhuwa Mukti Morcha. Bandhuwa Mukti Morcha were those people who were bonded laborers. Naturally, you can imagine the plight of bonded laborers, that they may not be having that kind of capacity to approach the court in a well-regulated form or filing a petition which could be sort of agitated by a counsel on their behalf. So that was the first case. The second case was judge's case, which we normally refer to as SP Gupta, where some of the judges were sought to be transferred during emergency and the entire theme was getting repeated. Now, the judges are in such vulnerable situation that though because of their position in life and the office that they hold, they would not like to come out in open and challenge the executive directions or any kind of transfers or invasion so far as their service conditions are concerned. So then the second lot was somebody who is vulnerable, though in a capacity individually to approach the court. So in those matters, the Supreme Court relaxed for the first time what are called the locus standi principles and said that any other person who is equally concerned in the matter or any a citizen who is governed by the ideas and would like to approach the court on their behalf should be allowed to approach the court. And then what is called, that gave rise to what we normally call public interest litigation. That is to say, a suitor or a litigator may not have interest in the matter personally, but he's advocating something, he's coming on behalf of a large section of population or a defined segment of the society and approaching the court for appropriate relief. So that is something which got coined as public interest litigation. That was the birth, that was the idea which germinated. But we haven't stopped at that level. So we have then expanded the matter and it has gone way beyond. Now take for instance, there are two litigations with which I was associated as amicus curiae. That is to say, court appointed advocate to agitate on behalf of that particular group. So one of them was T.N. Godavarman. The gentleman, nobody has seen who is this person. His idea was that under the forest policy of the country, 33% of the landmass must be under forest cover in the plains area, and 66% of the landmass in the hill area should be under forest cover in order to have a sustainable development, because that's the only way that the entire population can be well served. But unfortunately, the forest cover was dwindling. So he just sent one letter to the Supreme Court, which was converted into a public interest litigation. Naturally, the man concerned, he was only trying to ignite the spark. He only acted as a catalyst. Then the court took upon itself and court appointed amicus curiae. So in 1996, I came to be appointed as amicus curiae, and I held that position till I became the judge in 2014. So for 18 long years, the matter was going on. It was not individual-centric attention concerned to a particular judge. Successive judges dealt with the matter. So at least about 60-odd judges have dealt with that matter. But as an institution, the response of the court was to see that the green felling in forests is completely under check. The forest cover rises, which was originally only 19%. And as a result of the intervention by the Supreme Court, it rose to at least 23%. So therefore, that's the contribution of the court in seeing that the results are obvious. Then the second matter, which I can actually then share with you, was the vehicular pollution matter in Delhi. In Delhi, Delhi had used to have one of the largest fleet of city bus service, more than 11,000 buses. Now, the kind of emissions that diesel-driven buses used to have, that used to make the life miserable for the residents of Delhi. So the executive thought of that, why not convert it to CNG or natural gas driven buses. But then the executive then started stumbling because they had complete, the road was full of obstacles. Who supplies CNG? Where are the pumping stations? How will you convert everything in one single sort of year? The buses, the manufacturers must have the wherewithal, they must have the capacity. So that litigation was taken over by the Supreme Court as public interest litigation. Again, I was appointed as amicus. And in about 2 years' time, the Supreme Court saw to it that the entire bus service in Delhi is converted to CNG. As a matter of fact, in that pursuit, number of ideas came up. Number one, where does one get supply of CNG? So therefore, the directions to the government concerned that very well allocate a particular supply to Delhi. Done, number one. Number two, where are the pumping stations? So therefore, every now and then in some of the localities of Delhi, certain lands was sought to be acquired and pumping stations were involved and were instituted there. Then the manufacturers, who are the bus manufacturers, they had to convert to CNG. So therefore, at that level, certain directions were given. As a result of that intervention, in 3 years' time, the Delhi now saw complete changeover to what is called CNG bus service. Now, this we call, and this is what has been devised by the Supreme Court as what is called continuing mandamus, a new idea which emerged. That normally a mandamus would be issued and you are through with that, the court would cease to have any role thereafter. But here, the logic which prevailed with the Supreme Court was that one order, simply passing the order, may not serve the purpose. So therefore, you keep on passing one order, call for the reports, then next order, and that's how it goes on till you reach the final post. That is to say, what is the desired result in the matter must be achieved. And this is what the continuing mandamus as an idea has emerged in public interest litigation. So therefore, I just gave you the spectrum starting from cases like Bandhuwa Mukti Morcha, SP Gupta, and to the status that we have now reached, where the courts are taking control of some of the matters in what is called public interest. Yes.
Thank you. I just want to underscore a little bit of what you've said to put it in comparative perspective for maybe non-lawyers and even US lawyers. This is such an incredible innovation, and the Indian Supreme Court is the court of last resort for 20% of the world's population, right? Just think about that and think about how little we know about it here. And some of what the key features of public interest litigation as opposed to what is in America. In America, we need the person who has to bring a lawsuit has to be harmed. So that's called standing. But someone without standing can bring a lawsuit. So somebody can say Delhi is polluted because of these rickshaws. Any citizen can say we need to stop pollution through these rickshaws, and the Supreme Court will take it. And they'll take it directly without going through the various hurdles. And as he said, they'll appoint an amicus. So he was appointed for 18 years to follow through. So we're going to push the government to follow through. We're not just going to issue an opinion. So Supreme Court of US will issue an opinion and walk away, but there's a continuity. And they did this because of the people's, it views itself as the people's court. Okay, and so let me just also briefly, we had a full 10 minutes devoted to, but this is Vice Chancellor Raj Kumar. We're so delighted to have him here. He's the founder of the Jindal Global Law School, and he founded it basically 15 years ago, and now it's sort of the #1 school in India. So please.
Thank you so much, Sital, and thank you to the Dean as well. We are so delighted to have Honorable Chief Justice UU Lalit here at Seattle University Law School, which is one of our closest partners in the world. Sir, I wanted to respond to that articulation of the PIL institution that you talked about. For all the American lawyers and students here in particular, and they may be able to want to get a little more out of your formulation. In the year 1962, a noted American legal scholar, Alexander Bickel, wrote a book entitled The Least Dangerous Branch, where he talked about the role of judiciary, and he actually termed the judicial review as a deviant institution. And essentially, was very skeptical about the idea of a counter-majoritarian challenge where unelected judges are responding to what was essentially part of the democratic domain in which judges are entering in with good reasons. How would you respond to this idea and notion of counter-majoritarian challenge, which is, of course, uniquely American? And what are the justifications in the Indian context that the Supreme Court has consistently maintained to address the role of unelected judges taking upon democratic responsibility?
That's a very nice expression, unelected judges. I'll give you one classic instance. In the Indian Constitution, the judges of the higher courts, that is the Supreme Court, which is the Supreme Court for the country, and the high courts, which are equivalent to what are called your Supreme Courts for the individual states, like Supreme Court for Washington, New Jersey, etc., etc. So we have three-tier system: the district judiciary, the high courts, and the Supreme Court. Under the Constitution as originally drafted, the appointment of the judges of Supreme Court and High Court would be done by the President in consultation with the Chief Justice of the Supreme Court when it comes to appointment to the Supreme Court, and Chief Justice of the High Court when it came to the question of appointment of individual judges of that particular court. Over a particular, almost say 3 decades or so, the judges saw in the Supreme Court that perhaps the recommendations made and the appointments made were not so trustworthy, if I may use that expression. And they found that the best possible way which could be devised was, because the Constitution used the expression in consultation with the Chief Justice. So in consultation would mean what? Oh, here are 3 names. What is your opinion in the matter? The Chief Justice may give his opinion and the appointments could be made in a completely different way. So they said that in consultation has to be read as in conjunction. So therefore, there has to be primacy of opinion of the Chief Justice. So unless there are very, very extremely good reasons, you can't deviate from the opinion given by the Chief Justice. So there could be good reasons is there is a criminal profile to the individual concerned. These antecedents are something, not something completely above board. Some of these reasons, etc., etc. So otherwise, it must be what the Chief Justice has opined must be sort of observed by you. Now, they again did not want to put the power entirely in the hands of the Chief Justice. So therefore, they devised what is called collegium system. So therefore, first 5 judges of the Supreme Court, not just the Chief Justice, but next 2, 3, 4, 5 judges also would form a small club called collegium, and they would make recommendations, which would then be binding on the executive and the president so that the appointments can be made. Now, this was done by way of interpreting the provisions of the Constitution. So this was done in public interest. Why? Because the judges felt that if true democratic principles and true democracy has to survive in the country, judges must be independent. There is independence of judiciary which must be guaranteed, preserved, and sort of adhered to. And the only way it can be done is this. Very well. So therefore, they came out with this idea, which then germinated, took roots for almost 2 decades. Then came, now I'll come to the expression which is used by Dr. Rajkumar. The Parliament thought that all this is completely sort of beyond the purview of the Constitution. So they came out with an amendment to the Constitution and made an appointment, made the provision for appointment of what is called National Judicial Appointments Commission. The amendment to the Constitution. What did it actually signify? 6-member body, 3 judges of the Supreme Court, number Chief Justice, 2 and 3. So 3 judges, the law minister, and 2 legal jurists would form that committee, which would then make recommendations and advise the president on the issues of appointments, etc. The Supreme Court struck down that amendment. And on what ground? on the ground that this would be opposed to the idea of independence of judiciary. Their idea of independence of judiciary was what was actually put in practice by way of collegium was the only way in which independence of judiciary could be subserved. The then law minister came out with a remark, which was something akin to what fell from Dr. Rajkumar. He said in response to that judgment, this is nothing but tyranny of the unelected. Imagine two houses, Lok Sabha and Rajya Sabha, which is equivalent to your Senate and House, had passed the amendment. Since it touched upon the federal structure of the Constitution, it was ratified by more than 50% of the states, actually all the states. There was not a single dissenting note. And yet, 5 judges in Supreme Court could set aside that amendment. Now we have what is called Marbury versus Madison taken to the ultimate level. Marbury versus Madison said what? This is something which is the gift by this American judiciary. That anything, any legislative act, executive act, which is not in conformity with the Constitution must perish. We have gone to the level of saying even a constitutional amendment can even be, violated, can even be sort of invalidated on that ground, that Marbury versus Madison, same principle, that the constitutional amendment goes against the basic principles of Constitution. And this is what we say. So therefore, that's the level to which the Indian Supreme Court has gone. And this is again in consonance with Dr. Kalantri, that 20% of the population is susceptible to the jurisdiction of Indian Supreme Court. And Indian Supreme Court tries to do something which will better the lot of that entire population. So they're driven by one single idea that whatever we do must actually be in public interest, in the interest of general public, in the interest of the nation. So therefore, maybe that the parliament may have come out with an amendment, but if that amendment is something which goes against the basic idea of the Constitution, we will not hesitate to strike it down. And that's
So
Thank you
just
so much, sir.
go on, maybe ask the question also in a different way. And this is super, again, from a comparative perspective, so incredible that the judiciary of India, the Chief Justice, him and 4 of his colleagues basically nominate judges to the Supreme Court. They're very insulated then from executive interference in a way that we aren't here. And also they've strike down amendments of the parliament, right? We don't have the abilities. Our Supreme Court can't declare an amendment to the Constitution unconstitutional. I know it's very hard for us to amend the Constitution, so we haven't even really gotten there that often. But let me ask a question that Vice Chancellor Rajkumar asked in a different way, which is that these public interest litigations, when the Supreme Court issues decisions, like in the right to food case, says that people in India don't have enough, many people don't have enough to eat basic, and that's not fulfilling the Constitution. So the Supreme Court establishes a commission to ensure that everyone in India has enough basic nutrition. Now, how is that not, right? In America, we would think separation of powers. This is the role of the executive and of our legislature. So how, and you hear that often in India too, is that, well, let the executive do it, let the parliament do it. Why is the court interfering beyond its scope? And how do you justify that interference?
What you say is right. Separation of powers as a principle, as a fundamental idea, yes, a cherishable ideal. But at times what happens is that there may be laxity on part of the executive to take prompt actions in the matter. There may be legislation which is still not being implemented by the executive. Or there could be areas which are completely blank, which are not even ruled upon by either the legislative enactments or executive action. I'll give one instance. So far as women or ladies who are working in, say, at workplaces, if they are sexually exploited or there are sort of, advances on that front, there was no litigation, there was no legislation touching upon that particular topic. So Supreme Court observed it and said that this is a gap which needs to be filled up. Now, Supreme Court can't direct the legislature to enact a law. It can't direct the executive to come out with executive instructions, separation of powers. So Supreme Court then said that very well, we will devise the guidelines, number one. Those guidelines will have pro tem arrangement or life so long as the executive doesn't step in that particular field. So therefore, they issued guidelines saying that this is how you need to protect the ladies at workplaces. If there be any sexual advances, this is how they must be dealt with. There must be committees at every level. The committees must have so and so representation, including ladies on the committee. And those committees will look into the grievances and then come out with suggestions. And those, whatever orders are passed by the committee, must be obeyed. Now, that kind of logic, which is Vishakha principle, was devised by the Supreme Court. Why? Because there was no legislation, there was no executive instruction holding the field. So long as the field is completely a uncharted territory, according to the Supreme Court, separation of powers would not stop us from giving certain directions. But those directions would actually be in the nature of what is called a pro tem arrangement. Now, I'll give another example. In many professional colleges, say medical and engineering, some of the private institutions would charge very, very astronomical fees. Now, in order to curb that idea, in one of the public interest litigations or a litigation where it had the complete ideas about public interest, what the Supreme Court said is that we shall appoint for every state a fee fixation committee. We shall appoint for every state an admissions committee, and that will again be pro tem, and let it be sort of dealt with by the appropriate legislatures till they decide this shall be the committee which shall function. So therefore, that committee would then fix the fees so far as all these professional institutions in a state are concerned. That was what the idea came in Islamic education. Then the same thing again in Madhuri Patil, as to the status of a person, whether he is scheduled caste or scheduled tribe. They said scrutiny committees be appointed in every state. So therefore, Supreme Court, what it tries to do is, it is true that the separation of powers as a principle is something which is very, very a cherishable ideal and goal. But at the same time, on the touchstone of that, the population should not suffer. There has to be redressal of grievances. There has to be a solution offered to a problem. So Supreme Court tries to provide a solution, but it is well aware, cognizant of the fact that, we are not the final legislators. The legislation has to come from the right quarters. And so therefore, they would make an arrangement till the legislation takes over. So therefore, that's the idea, that's the logic.
Thank you so much, sir. That was a very powerful, not only a defense, but indeed an elaboration of the principle. In fact, my own view on this is not so much in relation to what the courts have, whether they've overstepped, but also if there are no other ways to seek such remedies, the courts inevitably have a big role to play. But my question remains about the expansion of the PIL jurisdiction. The reality today is, sir, that we have 50 million cases pending in Indian courts. The 50 million cases that are pending in Indian courts also means that there are huge social expectations generated out of this institution, the judiciary, of course, the Supreme Court, but also high courts and other courts too. And when we say 50 million, to be fair, a very smaller percentage of that is pending in the Supreme Court, a larger percentage is in the lower courts. My question to you is that if the Supreme Court and higher courts end up expanding its jurisdiction to take up so many matters that are quite legitimately coming through the PIL jurisdiction, do we run the risk of not having judicially manageable standards to determine what ought to be the cases where courts ought to intervene? Secondly, do we really run the risk of making other wings of the government far more weaker and somewhat not credible and worse, illegitimate in the process, wherein the courts are involved in deciding what ought to be the curriculum, what kind of examination system we should have, what kind of assessment patterns we should have, who should be recruited for what. These are aspects where other wings of government ought to be doing their role. Even when they fail, should the judiciary be taking that responsibility on its own, or make the other institutions accountable and make them do that job better?
See, there are two ways. Number one, judiciary takes the approach and adopts a stance that very well it's none of my business, it's the business of the legislature, it's the business of the executive, and so therefore I will fold my hands and simply watch in silence. Now, is that something which is expected of the highest court of the country? Or would you like your courts to be proactive and provide a solution to certain problems? I'll give one instance which recently happened and where I was involved. There has been a tussle between the chancellor, who happens to be the governor of the state, and the chief minister, who is the executive head of the government. When it came to appointment of vice chancellors to 36 universities in state of West Bengal, there was a head-on collision between these two authorities and functionaries. As a result of which, 36 universities in the state were without vice chancellors. A recommendation given by one would not be accepted by the other. The suggestion made by one would not be acceptable to the other. So it was a head-on collision between these two constitutional functionaries. The Supreme Court said, enough of that. They appointed me as the chairperson and gave me the complete authority that appoint selection committees, interview people, and make your suggestions. Put it in, alphabetical format, 3 names, and let the chief minister then pick up something out of that and make the appointment of the vice chancellor. Now, to somebody, it may appear that why should the Supreme Court have interfered in the matter? It's the function of the legislature, the chief minister, and the chancellor. But the head-on collision between these two authorities had seen that the universities were without vice chancellors for 2 years. Do you appreciate that, or do you just live with that? The Supreme Court chose to be proactive in the matter. So therefore, that's the reason one of the ideas comes that way. The second instance, if I may give, one public interest litigation which was filed was that very well what happens in legislatures is there are people with criminal antecedents who get elected. So therefore, the Supreme Court said that very well, you must declare what are your antecedents on the criminal side, what are your asset positions, how much of money do you have before you stand for election, so that the electorate knows exactly, am I going to elect somebody who has criminal antecedents? Now, the law never made any provision for that. And imagine the legislators may not even venture to make that kind of provision, which will be to their detriment. So therefore, the Supreme Court had to step in. Do they simply watch in silence? They chose not to. Now, it is true that, yes, there are cases pending, but that is something why? Because we have a very different system. Unlike US Supreme Court, where you have barely 70 or 80 matters in a year which come up before the Supreme Court for hearing. On one single day, in a bench of Supreme Court, there may be 15 benches on a particular day sitting in Supreme Court. There are 70 matters listed. So we hear the matters in court, 70 matters a day, every bench, and there are 15 benches. So what we have ensured is not a single voice should remain unheard. If there is somebody who has a complaint, if somebody has a grievance, the doors of the Supreme Court should be open to him. You may reject his petition, that's a different thing. But on the score of any technicality as to, number one, matters on facts will not lie before the court. Only certiorari will lie before the court. Sorry, we will not consider that. Every person is entitled to approach the court. Now, that access to justice is something which we believe and we take it to our heart in such a way that we have allowed number of people to approach the court. As a result of which, the docket explosion is something which has gone beyond the control of the judiciary. We need to have innovative ideas to curb that. That's a different thing. But the approach of the court is essentially what? To ensure that every voice of a citizen can get heard in that temple of justice.
Mm.
That's the logic.
Thank you, Mr. Chief Justice. We have about 10 minutes left, everybody, so we want to make sure that there is time for questions from all of you. And I thank Professor Kalantri for welcoming Dr. Raj Kumar to the lead table. Dr. Kumar, Raj is truly one of the most prominent, most successful university and law school administrators in the world and a very key partner to our institution. So we are thrilled that he is here. So questions from the audience, I can go to you and take the mic. We have only 10 minutes, so if you keep your questions nice and short.
Right. Good afternoon, everyone. My name is Adhavan Chakravarti Rajkumar. I'm in my final year of law at Jindal. And I first want to take this chance to thank our Vice Chancellor, Rajkumar Sir, and Professor Seetal Kalantri for giving us Jindal students the opportunity to come to Seattle and take part in this amazing program. It has been enlightening so far, to say the least. And so it would be weird if I didn't ask any question related to AI, since that's the program that we're doing. So I wanted to ask all three of the panelists, given that your vast expertise on the in law, about so while the situation of an AI replacing the judiciary is quite far-fetched and fantastical, and imposing a sort of sed lex dura lex system is not possible, do you think that judges in courts should be allowed to use the help of AI in sort of assessing the case, analyzing what possible crimes could be committed, and consequently informing their decision on how penalty should work? So,
Are there any other questions that we should stack up one after the other now? Yes, please. And then you could address all of them at the same time.
Sir, I've done a bit of work on public interest litigation, but not from a lawyer's perspective, but from a law and economic perspective. The law and economics literature completely says that a PIL is a failure because it has a high implementation cost and low incentive model. Because when judges come out and rule judgments under the PIL, they're not looking at how and efficiently these judgments can be enforced, because they are only at the judiciary level, but as far as the executive implementation of those orders, fails the cost efficiency angle. And law and economic scholars have for many years have looked into such models. And the second question, related question, is PL also, doesn't address the moral. It is a moral hazard issue, because people who are not involved or not affected, can also file a case under public interest litigation. So these are the two questions I have.
One more question?
Yeah, you go.
Justice Lalit, let me just preface this by saying how grateful I am, how grateful, in fact, we all are for your presence here. And it's a privilege to be speaking to you again. As a judicial clerk to the now retired Justice Hemant Gupta, I've had the honor of presenting a brief in your court before. And I'm also thankful to my father, Dr. Pawan Kumar, a former member of the Public Service Commission, Haryana, for arranging a phone call between us before. Sir, I have two questions for you today. You've had a variety of roles in your life, from the bar to the bench and now an educator. Which one of these roles would you say you found the most fulfilling, and why? And my second question would be for struggling first generation lawyers like myself. There are days which are devoid of hope or full of workload. And what would your advice be for someone like me? Thank you.
And that very important question about professional development. Sir.
Which one do I answer? All of them.
Whichever, yeah.
Okay, I'll first answer the second question because this is something connected with public interest litigation. To my mind, public interest litigations are very, very successful if they are handled carefully. I'll again give one example. There were projects which were put on the drawing board by one of the builders called Amrapali in Noida and Greater Noida. And what they would do is that the Noida and Greater Noida had a policy that they would allocate a plot of land upon deposit of just 10% of the cost of that that particular plot. Supposing if the cost of the plot was about 100 crores, it would be given at the value of just 10 crores. They would then open a scheme, announce a scheme, invite the applications from the prospective buyers, who would then deposit large amounts of money. They would raise construction, which doesn't take long if it is just about the structural kind of, skeletal idea. Raise it to about 15 odd stories. Whatever monies are which were deposited by the prospective buyers, on the strength of that, they would then invest in some other plot. So therefore, they would go on from A to B, B to C, C to D. So that's how the money would get actually, I won't say siphoned off, but at least invested in some other projects. They would also raise money from the public financial institutions, banks, and everybody. Now, if something goes wrong, all these 10 projects would actually be hitting the ground. Now, where do you find a solution? In an insolvency proceedings, the solution is not that the people would get roof over their head. So the insolvency would see to it what? The assets are distributed, assets are sold off, and creditors are paid. What happens to the prospective buyers? So therefore, Supreme Court intervened, and I was part of the bench, and we saw to it that every Friday from 2 to 4, we used to hold hearing and see to it that, the finances are raised. The finances are raised through public institutions. They were sort of directed to do something. As a result of that, about 70,000 people have now the apartments of their own. So we involved a National Building Corporation, which is a public sector financial public sector institution, which started doing the construction. So it's not as if that public interest litigations do not result in any kind of positive relief. They do, provided they are handled carefully. Correct? Number one. Number two, what you said is that at times, perhaps I think the persons who should be heard in the matter are never there before the court. And so therefore, something to their detriment may actually be the result of that public interest litigation. Again, it depends upon the judges who handle that public interest litigation. I'll tell you another classic example about the triple talaq. In triple talaq, one of the submissions of the then Attorney General was that look at this particular framework or the regime which is applicable under Mohammedan law. That you say that the marriage under Mohammedan law is a matter of contract, but the contract can be put to an end, can be invalidated by the husband by doing triple talaq. There is no corresponding right to the wife to put an end to the contract. So therefore, two parties to the contract are not being treated equally, and therefore invalidate this term on the ground that the husband cannot have unilateral right to put an end to the marriage. Now that was an invitation. Perhaps I think the judges, if they had accepted it. So I put a question to the Attorney General. I said that supposing if we invalidate it and tomorrow the husband wants to put an end to the marriage, what is the regime that the husband can actually approach the court and seek invalidation of the marriage? There is none. So therefore, the equal danger is that if you accept a particular submission and rule on that, what is going to be the resultant effect is the judges must also be alive to that. And so therefore, we did not invalidate triple talaq in essence, in all its kind of contours. We simply said triple declaration is invalid. But the right to the husband to put an end to the marriage by declaration talaq before a qazi is acceptable. So therefore, one must know where to stop and where not to go. So it all depends upon the judges who handle the public interest litigation. So therefore, that's where one has to be careful. Why? Because it would have actually resulted in chaotic situation. No husband could ever have then the right to put an end to the marriage. There is no forum, there is no law, there is no regime. How does one do that? So therefore, that answers perhaps, I think, your query. Now I'll come to the query which has been put by the young person. See, I'm a third generation lawyer. My grandfather was a lawyer, my father was a lawyer, my son is a lawyer. So it runs in my family for last 105 years or so. there are certain advantages. If your father is a lawyer, there are certain disadvantages also. There are too many expectations from you. You come with a baggage that you belong to a family, you come from that line of succession, so therefore people expect something from you. Whereas a person who comes as a first generation lawyer comes with a complete clean slate. So therefore, it is for him to write on that slate the way he wants to, and have the future as he would like to devise it. There have been number of first generation lawyers who have been judges, chief justices. Like for instance, Ramana was the first generation lawyer. Justice Kanvilkar was the first generation lawyer. There have been number, Justice Gawai, who is the present chief justice, Justice Suryakant, they are all first generation lawyers. So therefore, it's not as if there is a disadvantage. Life gives you some kind of advantages, but on the same side, there may be certain pluses and minuses. So therefore, one has to then deal with that situation and make the most of it. So therefore, don't get disheartened or discouraged by the fact that you are a first generation lawyer. Take it as an advantage and you'll go places. Now I'll go to the last question, which has been put on this AI front. See, when it comes to decision making is always very, very subjective. And the sovereign has actually put that power in me as a judge to decide according to my conscience. If I am supposed to be deciding according to my conscience and that's my oath of office, I can't delegate my functions to any other agency. Correct? I can use artificial intelligence to the extent which helps me in deciding the matter. Maybe in the form of what? What exactly are the pleadings? Take for instance, supposing if there is an IPR issue and about a particular literary work, if there is a question whether there has been plagiarism or not, you may use artificial intelligence to check whether is there any something which has been picked up from the earlier journals or not. But that is only in the nature of what? Aiding and assisting. You cannot delegate your function, the judicial function, the core function to anybody else. And that's the beauty of it. Otherwise, what you will be reduced to is computer justice. Then you don't even require judges. You just have to install 12 computer terminals in the court, just feed the basic ideas and get the result. That's not the idea, that's the logic. So therefore, artificial intelligence to the extent that it aids and sort of assists the judge, definitely welcome. But it cannot be substitute to the core judicial function. That's all.
Please join me in thanking Justice Lalit and Dr. Kumar. And big thanks to the phenomenal team that made today's event possible: Liz Gwynn, Karsten Gahout, and Christopher Mond in the School of Law, and Ashini Jagtiani Williams and Shannon Young from the India Center. Thank you to our co-sponsors, South Asian Bar Association of Washington and the Washington State Bar Association, both of which have members with us in the audience today. So thank you all for joining us this afternoon. Have a great rest of your day.